Good afternoon, ladies and gentlemen. I would like, first of all, to thank the invitation of Kocham to talk about the Brazilian data protection law, the Lgpd. It's a great honor for us to be here and to talk to you about this matter. I have a presentation, so just let me show you and we'll get much more easy to follow the presentation or the explanation. A little information about me. My name is Sergio Varela Bruna. I am a partner to Lobo de Riso, and I'm responsible for the regulatory and competition law practice of the firm. I've been working with data protection matters for a number of years already. I'm here today with Ine Shaw. Ine is a partner in the corporate and M&A practice. She and I will be here to answer your questions. It will be a pleasure if you have any questions, any doubts regarding the Lgpd on how to get your companies in compliance with the new law. Lobo de Riso is a full-service law firm. We basically cover all the areas where our clients may need legal support in running their businesses. And these are the main areas which we have in our firm. So let's go to the Lgpd. The Lgpd came into force only on September this year, but it was enacted back in 2018. It is a law that deals with privacy and the protection of personal information of individuals. The information that is covered by the Lgpd is individual information. It is not company's information. So it's important to bear that in mind from the beginning. Any company processes information, as you will see. So this law will impact virtually all companies in the country, because any company which is operational has and uses information from individual persons in their activities. The basic rule of the law is that companies may only process personal information if the company has a legal basis, that is, a legal authorization for the processing. I will talk a bit more in detail about legal basis, but let's first talk about what is the type of information we are dealing with and what processing means. So you will find on the bottom of this slide a translation of the wording that the law uses to define processing, and you will see that processing is anything. So processing is any operation carried out with personal data, such as collection, production, receipt, classification, use, access, reproduction, you name it. Anything that you do with personal data is processing. Even just storing personal data without actually using it. So anything is processing. And personal data, in turn, is defined as the information regarding an identified or identifiable individual. So it's either an information that links to an individual whose identity is known, or the information that, although not identifying that individual, can be used for the identification. So even if the identification is not obvious, is not expressed, if you can use the information to get the identity of the person to whom the information is related, then this information is personal also. So any processing of personal information requires legal basis, as I was saying. And what should be regarded as legal basis? These are the legal bases provided for the Lgpd. The main and most remembered one is consent. Consent is defined by the law as free, informed, and unambiguous manifestation of will, whereby the data subject agrees to her or his processing of personal data for a given purpose. Please remember, the legal basis is always linked to a specific purpose. So if you have legal basis for a particular purpose, you might not be able to use that information for a different purpose, okay? Unless you have another legal basis. So consent is the permission by the data subject for the use of his or her information for a particular purpose. Consent is the most remembered legal base, but it might not be the best one, at least for companies, because consent can be withdrawn. So if an individual is able to consent with the use of his or her information, he is also entitled to take consent back. And if consent is withdrawn, then the company will no longer be able to use the information for the purposes that the information was used. So there are other legal bases that likewise entitle companies to process personal information other than the data subject's consent. There is one that is meant for the compliance of legal or regulatory obligation. And so if a company is required to do something under the law with the information, then the company has the legal basis to do it. Companies may also use information to make credit assessments and to inform credit protection databases of transactions with individuals. So that is another authorization that the law brings for the processing. There is a very broad and vague authorization for companies to use information when they have a legitimate interest in the use. It is very broad, but the law also requires that this legal basis is used with caution, because companies have additional obligations when they are using this legitimate interest database. Oh, sorry, legal basis. You may use information whenever that is required to protect the life or the physical safety of the individual. You may use information when the information is necessary to enter into an agreement with the particular individual that will enter into the agreement with you. You may also use information to defend your interests in judicial and administrative or arbitration procedure. And there are also other legal bases that are more meant for research and government. So government has, and that is here and below in this box, the legal authorization to use personal information to perform public policies. There is also possibility to use personal information for study and research and the protection of health. So companies also have to grant individuals, data subjects, with the new rights that are granted to them by the law. The new rights are these. Basically, the individual has the right to ask confirmation of the existence of the processing, has the right to access the data that is being processed, has the right to ask correction, the correction of data that is mistaken, is wrong, has the right to require the blocking, the deletion, or even the anonymization, so the elimination of the features that enable one to identify the person that is related to the data. Whenever the data is unnecessary or excessive in relation to the purpose of the processing, the individuals have the right to data portability. So, like what happens with phone numbers, nowadays you can migrate your phone number from one operator to another operator and keep the same number. Similarly, data subjects will be entitled, or are already entitled, to ask a particular company to transfer his or her personal information to another company, so that the company uses that information on behalf of the individual, or in the interest of that particular individual. Individuals can require the erasure of their data. They can ask companies to identify which entities with which the controller, the data controller, has shared that individual's information. The individual has the right to be informed of the possibility of denying consent, and which would be the consequences thereof. So, if, for instance, if an individual is required to provide information in a website in order to use a service that is offered by the website, the website should inform the individual that if consent is denied, then the person might not be able to use the services. The possibility to withdraw consent is also a right of individuals under the Lgpd. And companies have obligations in respect of the legal data protection regime. So the companies are under obligation to inform data subjects of the data processing if they start processing someone's information. The company must keep records of the processing operations. The company must disclose the identity of the company's data protection officer. In Brazil, the data protection officer is called by a much less fancy, so to speak, word, which is the encarregado. But the functions of the DPO and the encarregado are similar. So we are usually translating encarregado by data protection officer. The company is under obligation to inform security incidents that happen to data subjects and to the data protection, the Brazilian Data Protection Authority, the ANPD. The company should adopt technical and administrative security measures against unauthorized access to the information. Companies are also required to educate and train employees and third parties about personal data protection. And finally, the company is required to receive and reply the complaints presented by data subjects or the ANPD, the Brazilian Data Protection Authority. What are the risks for not complying with the law? The main and most immediate risk is reputational. So if there is a security breach, the company might be involved in a public scandal. For instance, I remember a couple of years ago, maybe a little more, but there was, I think there's still a company called, I think, Ashley Medicine, which was running a website, a service of date matching. But the date matching that the company was running was meant for married people. So there was a data link, and those that were, you know, seeking the dates in that particular services had their information disclosed to the public. So in that particular situation, there was a huge, I would say, risk of damage for the people that were using the service. And there was a lot of press coverage about that. Obviously, it was very interesting for the public, such a data link. So the company, when is involved in a public scandal like that, is damaged in its reputational and in its image immediately, no matter if the company is innocent or not. The exposure is immediate. There are also fines that can be significant. Fines can go up to 2% of the turnover of the company in the previous fiscal year, or 50 million, whichever is the highest amount. So that is significant anyway. And the grounds for avoiding liability are very narrow. So there are only 3 situations where the company can avoid liability, and those are by proving that the company did not process the data related to a particular loss, that the processing, that's the second possibility, was made in compliance with the Lgpd, and finally, the company may claim that the damage was caused exclusively by the data subject, with no participation or involvement of the company. Otherwise, the company will answer for losses caused by the security breach. So, what companies need to do, and in order to be compliant with the Lgpd. So the first thing companies need to do is to map out the situations where the company is processing personal data. So where are the places in my company where I can find data, personal information? Personal information, unfortunately, is everywhere. So from the reception of the company, where receptionists take note of the names of visitors, the persons who they are visiting, the place they came from, their phone numbers, whatever, their ID numbers, those are personal information. So from the reception to other departments, so such as human resources, Any company has information about its employees. It has information about the children of the employees for providing health insurance coverage, for instance. The financial the financial department will have information about the contact persons in other companies, in banks. The marketing department will have information on the customers, on the clients, on potential customers. So information is everywhere in the company. So, and the company needs to identify which information it has and what are the uses that the company makes with that information. So the mapping out is the first step. Afterwards, the company needs to establish whether there is legal basis for the use of the information, for the processing of the information. It should review security measures because the company is responsible for the security of the information. And the company should make records of everything in the development of this project. So the company needs to store records of the decisions and the verifications that are made during the whole process. And in this digital repository that we usually call it, the company should answer questions like these. What kind of data is collected? Who is the data subject? And what is the purpose of the collection? How will the data be processed? Where will the data be transferred to? And who will receive it? What is the legal basis for each step of the processing? Where and for how long will the data be stored? Who can access such data? Are there appropriate security measures? Have risks been mitigated? Is the processing limited to the purpose of the collection? So questions like these should be answered and the answers recorded in documents that will be finally stored in this digital repository. The digital repository will serve as proof that the company made a reasonable assessment and took sound decisions regarding the data processing. After you complete your review, you will have measures to be taken. You have new policies to be implemented. So you should put your hands in the work. So you should implement the measures that you've planned. And you finally need to educate your personnel, educate your employees about the value of data protection and make them aware of the measures that they need to take if they are required to do so. So it's like a Grand Prix. You should start a project, and this project is not a legal project. It's a project that the company needs to run as many other projects that the company usually has. So the first thing to do in any project is to define a project leader, and this project will require a working group because there are, as we saw, there are many departments of the company that have personal information. So you will need to have people that know the use that is made with the information to participate in the project and bring solutions and suggestions for the processing of the information or the identification of legal basis. You should set up a budget for the project. The project will require investment. then you should, structure a plan, an action plan, approve your budget, and then start mapping out the data. So when you start mapping out the data, you're already here in the corner 6 of our Grand Prix. You will map out the data by identifying the categories of data, the purpose of the processing, the data flows, where the data is coming from and where it is going to. Identify your security measures, the contracts with third parties that receive or transfer information to you. So you should amend many contracts in order to have appropriate provisions to protect your interests in connection with data protection. You should identify your policies, adapt them, create new policies as necessary. You should, identify legal bases and risks. So this is the mapping out. And finally, you need to implement your actions. So you should eliminate the data which is not necessary. You should secure legal bases. If you don't have them, you would be required to take action to obtain the legal basis. You should improve your safety systems. You should organize the records of the processing, and you should build this digital repository that I mentioned. Review policies, review agreements, train your personnel, train your employees, and then finally you should monitor and update your program. It's like a building. First you prepare the land, then you build the structure of the building, and when the building is done, you need to maintain it. You need to keep everything operating perfectly, and you should update the systems and the procedures that you've created as necessary to keep everything up to date and in compliance with the law. Once again, I would like to thank you for the opportunity of talking about the Lgpd. And as I said, we will be glad to answer questions that you may have. If you have any doubt, please let us know. It will be a pleasure for us. Thank you very much.